Hello everyone, and thank you for joining us for our last segment on the H-1B lottery process. My name is Stephanie Grattan, and I am an attorney in Coley Jessen's Employment and Labor Group. For the past several weeks, Ryan Sevchuk and I have presented a series of short videos providing an overview of the H-1B lottery process. Today is our sixth and final segment in the series, and I will be discussing pre- and post-approval issues to consider for H-1B beneficiaries. First and foremost is travel. As Ryan mentioned last week, an H-1B petition may be filed seeking a change of status or seeking consular notification of the approval. The difference between the two is that if a change of status is requested and approved, then the beneficiary's immigration status automatically changes to H-1B on October 1st by operation of law, without the beneficiary needing to depart the United States. In contrast, when consular notification is sought, the beneficiary must depart the United States and obtain an H-1B visa at a United States embassy or consulate abroad before being able to return to the U.S. and work in H-1B status. Most individuals, especially those already in the United States, prefer to seek a change of status rather than consular notification, and there are a lot of advantages to doing so, because upon approval, the beneficiary does not need to take any extra steps in order to commence working in H-1B status come October 1st. However, if the beneficiary has any plans to travel abroad prior to October 1st and is seeking a change of status, then the beneficiary cannot travel while USCIS is processing the request, or else the change of status portion of the request will be deemed abandoned. While USCIS may still approve the H-1B petition itself, the beneficiary would not automatically change to H-1B status on October 1st. Instead, the beneficiary would have to leave the U.S. again and apply for an H-1B visa at a United States consulate, or, if otherwise permissible, the employer could submit a new petition to change status to H-1B after the beneficiary's return. Note that if the H-1B change of status is approved before the beneficiary departs the U.S., the change of status portion will still take effect on October 1st, as long as the beneficiary has returned to the U.S. before that day. Another post-approval issue for consideration are any potential changes to the approved terms and conditions of employment. H-1B petitions are company-specific, employee-specific, position-specific, location-specific, and salary-specific. Any change to any of these elements of the employment relationship may necessitate the filing of a new or amended H-1B petition. For example, if the employment relationship ends between the company and the employee prior to the expiration of the approved H-1B validity period, then USCIS must be notified. If the H-1B beneficiary desires to work for a different company, then the new company must file an H-1B transfer petition on the beneficiary's behalf. If the company desires to sponsor a different H-1B beneficiary, then a new H-1B petition must be filed for the new beneficiary. And if the beneficiary has not previously been counted under the cap, then the company may only file a new cap-subject H-1B petition as part of the lottery process. If the employment relationship remains intact, but the beneficiary receives a promotion or is transferred to a different location, then counsel should be sought on whether an H-1B Amendment Petition must be filed. As a general matter, if the new worksite address is located in the same area of intended employment, or MSA, then notice must be posted at the new worksite address. But an H-1B Amendment Petition is not required. Whereas if the new worksite address is located across the country in another state, then an H-1B petition would be required. Also, if the beneficiary switches roles within a company and is now performing in a different capacity, such as going from a software developer role to an HR role, then an H-1B Amendment Petition must be filed with USCIS. However, if the change in position is to a similar role in the occupational category, such as going from a software developer to a senior software developer position, then an H-1B Amendment Petition likely does not need to be filed with USCIS. The last post-approval issue for consideration that I'll discuss today is the limitation on stay in H-1B status. According to USCIS's rules, the maximum period of authorized stay in H-1B status is 6 years. And this 6-year period includes time previously spent in L1 status, H2A, H2B, or H3 status. There are several ways a beneficiary may qualify to extend H-1B employment beyond the 6-year limit. The first is seasonal or intermittent H-1B employment in the U.S. This is accepted from the 6-year limit. And intermittent or seasonal employment is defined as employment in the U.S. that is for an aggregate of 6 months or less per year. Second, any time spent outside the U.S. during the 6-year period may be recaptured and added to the end of the otherwise applicable 6-year limit. For example, if the H-1B beneficiary travels home for 1 month, then that 1-month period spent outside of the U.S. may be recaptured, and the H-1B beneficiary's overall stay may total 6 years and 1 month. Third, if permanent sponsorship has been undertaken on the beneficiary's behalf, and the beneficiary has an approved I-140, then H-1B extensions may continue to be sought in 3-year increments until such time as permanent residency is obtained. Fourth, if permanent sponsorship has been undertaken on the beneficiary's behalf, but there is not yet an approved I-140, then so long as a labor certification application or PERM application was filed on the beneficiary's behalf by the end of the 5th year in H-1B status, then H-1B extensions may continue to be sought in 1-year increments beyond the otherwise applicable 6-year max. Last but not least, if the beneficiary remains outside of the U.S. for 1 continuous year, the beneficiary will be eligible to be considered in the H-1B lottery anew. The takeaway here is that if the employer and beneficiary desire for the employment relationship to extend beyond 6 years, then permanent sponsorship should be considered, or, if appropriate, a change to another visa category. Thank you again for listening, and we hope you have enjoyed our video series on the H-1B lottery process.